Did we see this happen with Ghislaine Maxwell before her trial started? No. Why is it against Trump? Well, it's because they're not going to get the trial done before the election. The government prosecutors, as they're reading this, like, they know what that means. An opening immunity brief. But they're like, well, it is an opening immunity brief. So what if it's 180 pages? Says Molly. The special counsel's office is seeking to do so by turning criminal procedure on its head in order to file a 180-page hit piece against Trump. The illegitimate prosecutor, Jack Smith, is now going to be submitting a monstrous, disgusting filing, and it's going to smear Trump and months before the election. Now, Trump's defense has responded to this and saying, no, we oppose it, and we'll read through both filings here now. But this is what the illegitimate prosecutor, Jack Smith, said starting off. And he dropped this one on 9/21, landed on Chutkan's desk, and he surprised everybody by saying, we're going to have a big 180-pager coming soon. Here's how they start from Jack's office. They say, all right, look, in the Supreme Court case, they said that the Supreme Court said that we have to do a fact-bound immunity analysis. They wrote, necessarily fact-bound immunity analysis. They gave us some clips from the excerpts from the decision, determining whose characterization may be correct and with respect to which conduct requires a close analysis, right? So close analysis. And therefore, fact-specific. Any of this could be relevant. So they say the Supreme Court remanded to you, Chutkan, to do that, to determine in the first instance, with the benefit of the briefing we lack, whether the conduct was official or unofficial. They're saying, Chutkan, you can choose. It's going to be your decision. So to fulfill the Supreme Court's remand, to do what the Supreme Court told us to do, in a status hearing on September 5th, we propose filing an opening brief, which would be a comprehensive discussion and a description of both pled and unpled facts, so that all parties in the court know the issues and the court needs to consider that the Supreme Court told us to do. Now, the government also indicated that the brief would include a substantial number of exhibits. So they're actually just going to present the evidence because they can't get a trial out before the election. They're just going to file it. In a scheduling order entered the same date, the court ordered the government to file an opening brief by September 26th. That's going to be this week on Thursday. Now, the court has been directed to conduct a detailed, fact-bound, and thorough analysis. Because the court will make determinations in the first instance that will be subject to exacting appellate review, it's essential that the court ensure the record in support of its determinations is complete. So Jack is kind of throwing a temper tantrum here, and it's pretty clever, right? They're just cherry picking from the Supreme Court what they can so that they can make a big smear job. Hey, the Supreme Court said we have to have facts, so we better just give them all the facts they want. How many pages can we have, Chutkan? She's like, yeah, I guess if they want facts, we'll give them the facts. The government believes that a comprehensive brief by the government will be of great assistance to you, Judge, in creating a robust record, and the government would thus exceed the typical limit for a single motion. The opening motions and oppositions are 45 pages, and 25 pages are for replies. But the government already estimates that they're going to need a lot more than 45 pages, obviously. 180 pages is what is going to suffice. It's like a book. The government estimates that roughly half of its motion will consist of detailed factual proffers and extensive footnote citations to an exhibit increase the motion size by more than 30 pages. So the footnotes, it's just insane. The government conferred with the defense. The defense obviously opposes the motion. They request a deadline on September 24th. They just filed their opposition. We'll read it now. For the court's awareness, the opening brief and its exhibits contain a substantial amount of sensitive material as defined in the protective order. And so consistent with the order, the government is going to file a motion for leave under seal that attaches the unredacted copy and then file the redacted copy on the public docket. Because of the extensive and time-consuming logistics, we respect a decision soon. Signed by Thomas Wyndham, the motion, one of the more intelligent people on the team. Molly's the highlighter gal. She just sits there and highlights things and puts sticky notes on stuff. I'm like, yeah, good job, Molly. Doing great. So they submit that. You can present that evidence at trial if you want to, so it can be cross-examined, but there's a reason we don't see trials happen in public filings like this. It's like, did we see all of this happen with Hunter Biden right before his trial started? No. Did we see this happen with Ghislaine Maxwell before her trial started? No. Why is it against Trump? Well, it's because they're not going to get the trial done before the election. It is just a smear job by the courts. So then Trump's people have come out and they've responded. Trump's people say, no. President Trump is here and he now opposes Jack Smith's motion for an oversized opening immunity brief, saying that Trump here now respectfully submits this opposition to Jack's 180-page, quote, opening immunity brief. See those quotation marks? That's the defense attorneys mocking them, and they should be mocked. Now, the motion is a new development illustrating the unprecedented and irregular nature of Jack's approach once this case came back down from the from the Supreme Court, as they are now seeking permission to file a document that would quadruple the standard page limits in this court. Jack cites no case law in which that relief was ever granted, just as they cited no authority for their last request, which is to file a freestanding brief related to presidential immunity that's not even responsive to our motion, so he just files whatever he wants. Now, Jack's proposed approach is fundamentally unfair, Your Honor, as the office would attempt to set a closed record for addressing unfiled defense motions by crediting their own untested assessments of purported evidence. They're going to say these are the facts that happened. They're not even responding to our discovery motions. Is this true or not? You do interviews, you do investigations. What does this evidence say? Let me investigate that. Your cops, I need to talk to him, get him on the phone, and schedule interviews, all this stuff. So they're just going to drop all this evidence like flat on the public docket for everybody to see when Trump hasn't even gotten the discovery they need, denying Trump an opportunity to confront their witnesses, which is part of the Constitution. It's called the Confrontation Clause. And we want that to happen at trial so you can cross-examine them. You don't have trials in public filings before the trial starts, and preventing the defense from even getting the evidence. The hypocrisy of this approach is demonstrated by Jack's earlier arguments, in this case and in Florida where he got thrown out, that using discovery materials in public filings could taint the jury pool and bias potential witnesses. Their requests are also inconsistent with the federal rules of criminal procedure, and the court should reject them until the threshold legal questions that have already been identified by the Supreme Court are addressed, that's immunity, and discovery is complete. Now today, Jack's office informed President Trump that they wish to file a surreply relating to Trump's pending discovery motions, which is an extra response, in other words. Well, maybe they should focus on that document, they say. Ooh, they're getting snippy here. And on complying with their obligations rather than pushing this filing to support their politically motivated agenda. So you see, they're saying, oh, they just send us an email today. Like, hi, can we have permission to file this other motion? They're like, yeah, you can file that one. Maybe you should focus on that one, not this other book report of yours. Now, the opening immunity brief, again, in quotes, your 180-page opening immunity brief that's a book, as described in the motion, would be an improper special counsel report masked as a superfluous filing seeking advisory opinions in a criminal case. Yeah, so you can't call it an opening immunity brief, okay? You're basically like flouting your homework in front of the teacher to say, do you like this? Is this good enough for you? Because I'm going to be presenting soon. Can you just take a nice look at this? So it's an unnecessary, superfluous filing seeking advisory opinion, seeking the judge to give you hints, which is illegal, about how the case is going. Should I file this motion to dismiss or not? Judge, what do you think? Can you tell me, should I do this or not? How are you going to rule on it? The document would also violate the presidential immunity doctrine, which says he's immune from much of that evidence. It would taint the integrity of these proceedings completely, increase the First Amendment harm resulting from the gag order, and violate the Justice Manual. All they don't care about is perfect. It's like exactly what they want. They're like, yeah, Chutkin's reading this. She's like, that's great. I can't wait to do every one of these things. It's going to be a beautiful morning. Accordingly, for the reasons set forth, the court should deny the motion and grant Trump's request to reconsider the current schedule. So here's how they say this is the right decision. Now, the court does not need 180 pages of, quote, great assistance, whatever that is. This is going to be great assistance for you, Judge, whatever that is, from Jack's office to develop the record necessary to address Trump's immunity defense. Calling the document fact-bound does not make it so. Now, the office aims to proffer their untested and biased views to the court and the public as if they're conclusive, like this is a finding of fact. And that's how this is going to be treated, by the way. This will be treated like a Mueller report or like Durham report or like a special counsel report. They'll call it that, actually. Chutkin will allow it, and then this, of course, will end up all over the news, which is the whole point, because they're going to try Trump in the court of public opinion if they can't try him in the court of law, which they've been doing for the last many years. But they'll call it the special counsel report. People will think it's official. People won't recognize that it is part of Jack Smith's fake prosecution. But this is contrary to the law, to the procedure, and to the custom. Now, courts frequently develop factual records to resolve legal questions in criminal cases by focusing on their actual motions and narrowly addressing disputed issues. There's no basis for abandoning those procedures in this case. Like you file a motion to dismiss the case because of officer misconduct, and you have an evidentiary hearing on this misconduct, and stuff's called, and then it's settled, and maybe the case is dismissed or whatever, and it's gone, it's disposed of. But it's not the full trial. You're just talking about that one little thing in the case. You don't just dump everything out there and just say, hey, look at it. So just the opposite. Adherence to procedure and protocol is necessary to ensure fairness and justice. You don't just get to say 180 pages because whatever. Now, if the motion is granted, Trump wants 180 pages himself, and he wants to file a surreply too. Now, allowing Jack's office to litter the docket with an unnecessary tome of inconsistent would be inconsistent with the fact that there are dispositive threshold legal questions identified in the Supreme Court case that need to be resolved first. We have to talk about immunity before we can get to these other issues. Here are some of the problems. Immunity is absolute. Immunity also attaches to any allegations about Pence. There are serious questions about whether Merrick Garland has even appointed a lawful special counsel, and that's from Judge Thomas's concurrence, right? Judge Thomas is also asking, is Jack Smith a real boy? Answer, no, he's not. In effect, the office would be seeking an advisory opinion on unraised legal issues that this court may never reach, and it's inconsistent with the rules. And so Jack's motion, his opening brief, 180 pages, again in quotes, is particularly improper. And the government prosecutors, as they're reading this, like they know what that means. An opening immunity brief. But they're like, well, it is an opening immunity brief. So what if it's 180 pages? Says Molly. President Trump has a due process right to the prompt production of evidence, and the office is currently violating the requirements under the rules. We need the evidence before we can move forward, and they have not given it to us currently. There are rules that are safeguards. Jack is violating those safeguards. There is no other explanation for his insistence on moving forward with this book report, this opening immunity brief, before live discovery disputes are even addressed. There's going to be materials in there that we don't even have in our discovery. Given these disputes, it's pretty troubling, they say, to see Jack Smith try to chart such an irregular course in this case. Now, the path that Jack Smith is trying to pursue would be an independent violation of presidential immunity on top of that. A 180-page filing would embody the type of improper extended proceeding that the Supreme Court has already forbidden. The court may not adjudicate superfluous presidential immunity issues, including by allowing the office to file this monstrosity if President Trump says and can establish there is immunity. The office wants so desperately to bar President Trump from the opportunity to make that showing so that they can improperly air their biased list of grievances. That's all they want. They're out of options. This filing would also impact witnesses. It would taint the jury pool. Jack Smith is ignoring the penalties, the repercussions of this. They say, well, we could have a protective order. They say that Trump has no right to release this discovery material, but now they're all of this public, right? So they say to Trump, you can't give any of this information out, but we can. In 180 pages, we'll just dump it all out onto the docket. Previously, they said it would be improper to disseminate evidence of this out there. You can't get this out, Trump. Now they're going to file 180 pages. They're going to have an appendix. It's going to pollute the jury pool. In Florida, based on similar arguments, they sought to maintain a bunch of this under seal too. When the office disagreed in Florida with factual arguments by Trump, they sought a gag order on Trump there. Look, we said the same thing here. The requested 180-page brief would be tantamount to a premature and improper special counsel report, which is exactly how they're going to call it. They say he's a special counsel, even though he's not. The report would be premature because we have not reached the conclusion of the special counsel's work, except in Florida, where a federal court, Judge Eileen Cannon, shout out, concluded that Jack Smith lacks authority to conduct any proceedings at all because he's not a real boy, as President Trump will demonstrate in this case pursuant to another motion we're going to file. The report from Jack would be improper because it's going to present legal conclusions contrary to the presumption of innocence and present privacy concerns for potential witnesses and uncharged parties. This is a long recognized problem with these documents. During hearings that led to the expiration of the Independent Counsel Act, Janet Reno explained that the report requirement cuts against many of the basic traditions and practices of American law. We have an adversarial system. We value privacy. We presume innocence. We have the right to confront our accusers. We contest evidence in a court of law, cross-examinations and due process. We don't drop big 180-page criminal book report dossiers and call it a trial. That's what they want in this country. That's what they want the future of justice to be. You're watching it be constructed right now. They had their way. This would be good enough. Just submit the report. Call it a day. Jack Smith's totally honorable. The DOJ released accompanying 1999 regulations that any reports will be confidential because it's just a big smear job. And then they got rid of all of that entirely. In this case, including through the motion, Jack's office is seeking to release voluminous conclusions to the public without allowing Trump to confront their witnesses or to present his own evidence. They want to release this before 2024. Now, the strategy reflected by the motion would increase the irreparable harm by the gag order in this case. Chutkan's already gagged him. False public allegations by Jack's office presented through a document has no basis in a traditional justice process. It's going to undoubtedly enter the dialogue around the election. We're all going to be talking about it, obviously. The gag order prevents Trump from explaining in detail why Jack is a biased and selective liar and why he's inaccurate. Trump can't even respond to this because Chutkan has already gagged him. While the D.C. Circuit Court modified and addressed the gag order previously, the court was careful to note that the general election is almost a year away and will long post-date the trial in this case. Circumstances have changed, haven't they, Judge Chutkan? Trump is the leading candidate and the election is just weeks away. The office cannot be permitted to issue a massive and misleading misleading public statement that is not responsive to a defense motion at all. Like, Trump's not filing anything. Motion to dismiss. He has filed a bunch of things, but Jack wants this as his opening brief and risks adverse impacts to the integrity of these proceedings while simultaneously insisting on an unconstitutional prior restraint on Trump's ability to respond to their inaccurate assertions while he's campaigning. The huge public filing that his opening brief portends would also violate the Justice Manual. The Justice Manual says actions that may have an impact on an election shouldn't be taken. Federal prosecutors and agents may never select the timing of any action to affect an election. Jack Smith is doing it to, literally to, impact the election. Prior to this case, the DOJ followed an unwritten 60-day rule, summarized as follows. We're less than 60 days out, my friends. Comey said, "We avoid taking any action in the run-up to an election if we can avoid it." Loretta Lynch said, "In general, the practice has been not to take actions that might have an impact on an election." See that? Loretta Lynch said it. Even if it's not an election case or something like that. Don't file big, disgusting smear job motions that are not even legitimate from a legitimate prosecutor right in the run-up to the election. Oh, how times have changed. Former Attorney General Sally Yates said to me, "If it were 90 days off and you think it has a significant chance of impacting an election, unless there's a reason you need to take that action, you don't do it." Wonder what Merrick Garland's going to say on this one. We all know. The whole point of this case is to impact the election. It's literal election interference. It's been happening for years. Departures from these practices should never be countenanced. And there's some good words in this filing because they risk allowing prosecutors to impact national elections. But the situation is even worse where here, the special counsel's office is seeking to do so by turning criminal procedure on its head in order to file a 180-page hit piece against Trump on the eve of the election. And so for all of these reasons, the court should deny the motion and reconsider the scheduling order. Reject Jack Smith's lawless 180-page special counsel report in defense of their defective superseding indictment before they're even in compliance with their discovery obligations. And I don't know who wrote this one, but there were some nice words in there. Countenance, man. Another one. Another good word. But another good motion. And it's just so transparent on its face. You can see what they're doing. 180-page opening immunity brief so that Jake Tapper and Rachel Maddow and everybody can say, "Oh my gosh, can you believe what Trump did?" And Jack Smith's office was never, intended to go and investigate something and like return a report like an independent OIG or something, which they would frame it as. He's just an unbiased, nonpartisan prosecutor. No, he's not even legitimate. Wasn't even appointed by the president. It was never confirmed by the Senate. David Weiss was both of those things. Robert Hur was both of those things. So we know that they can do that, but they don't do that. So instead, since they're losing this case so badly, they just want to drop their giant report. I think Chutkan's going to allow it. I think she'll allow it because what else do they have? But we'll be here to cover it, my friends. Thank you for subscribing wherever it is you're watching this video. Thanks for liking this channel. Thanks for liking this video. Thanks for inviting someone you know or love to come over here and check out our channel. And we'll look forward to seeing you back here on the next one.